Thanks. Now, the Supreme Court has pulled up the government after it submitted the one rank, one pension payment roadmap in a sealed cover. Justice G.Y. Chandrachud said that sealed covers are fundamentally against the judicial process and need to be ended. Ashmit joins us now with more on the observations made in the Orope case and the comments that came in from the Supreme Court on the sealed cover jurisprudence. Ashmit.
Well, the Chief Justice of India, Justice D.Y. Chandrachud, making his position exceptionally clear that he is personally averse to submissions being filed by the centre, by the government, in a sealed cover. Now, this is something that he's taken exception to in the past and made his view clear today as well. And now, all of this case, today's hearing was essentially in the one rank, one pension or the OROP case that was pending before the Apex Court. The hearing, the subject matter essentially was regarding compliance of a previous Supreme Court order which had directed for these pension dues to be cleared by March 15th. That did not happen, and therefore the centre, represented by the Attorney General, sought to clarify its position, but in a sealed envelope only for the judges and not for the other parties. Now, that is something that the Chief Justice did not like, made his views clear. He pointed out that this is fundamentally against the rules of justice, that this public proceeding, there can be no secrecy in that there needs to be full transparency, and further going on to say that he's wary of allowing these sealed covers to ensure that the high courts don't start beginning this practice of accepting submissions in a sealed envelope. Now, this is the view that the Apex Court has given, has said that all the submissions that the centre has to give can be made in public, can be passed across the bar and need not be in a cover. What's interesting is that very recently, even in the Adani Hindenburg case, at the time the centre had sought to make its submissions in a sealed cover, and that too had been rejected by the Apex Court. So the CJI taking a firm view, no room for secrecy, no sealed cover, transparency is the way to go.
The practice of a sealed cover is the antithesis of having an open court. There are exceptions to this in the sense that Section 123 and Section 124 of the Evidence Act provides for the state, that is the government, producing documents only for the consideration of the court. These are called privileged documents. Now, such documents have to be produced, they can be produced in a sealed cover, along with an affidavit of the head of the department concerned. So, if it's from the Government of India, for example, a particular ministry, then the secretary of that ministry has to give an affidavit giving the reasons why the documents are privileged and why they should not be disclosed to the public. The court will then decide whether in fact the documents are privileged or not, and if they are not privileged, then the court will unseal the documents and make it available to the public for scrutiny.